Good evening, morning, afternoon, whenever you're watching this, BUL3130. Thank you for a good first half of the semester. Looking forward to a strong second half. The grades for the midterm have been pretty good. Happy with that. So it seemed like everyone that took the midterm did pretty well on it. One thing on it before I go further into the video, if you have questions about a question that you missed, you think maybe there should have been um, an answer different, reach out to me so I can look at it. I do not have a problem looking over those, checking to make sure that the system did not mess up in any way as it was developing that question. They are pulled from the same question banks as your quizzes that you do in Cengage, so it's fairly well structured. It all comes from there, but just in case there were some questions, reach out to me and let me know so I can go back and look at it. We're not too far out; they cannot be fixed or remedied and adjusted. All right. So the purpose of this video is to go over chapters 32 and 33, the chapters out of business law, Smith and Roberson's business law for this module. So I want to spend some time going over them. This will be similar to the videos that I have posted. This will be a new one for this term, though. I've adjusted a little bit this term. So for the second half, some of the videos will be new based upon what information is going into them. So this is a video for the second half, chapters 32, 33, this is the spring of 26. So make sure that we're right on there. And that also helps me know when I'm recording this video. So when I look back at it, I'll know. All right. So the first thing I want to do is share the screen with you. Let's see, the screen I want to share. Let's go with the screen. And we'll start off with 32. So we'll start with chapter 32. Chapter 32 is about limited partnerships, limited liability companies. Now, for the sake of brevity, I did take out the information on limited partnerships. Please read the book on it. I wanted to go with what I thought was probably the more relevant to you. And so for me, that is the limited partnership or an LLC. Your LLCs are always a little bit better option. Let me change the screen I'm sharing here so I can share them I'm giving you the right information. All right, so I do have this on a longer screen, so it may look a little different. All right, so the point of a LLC, and we'll get to that slide. It's a little different than I'm used to, so just bear with me here. All right, so the point of an LLC is to give the members. Now, this is where you do see a difference in any other type of uh, business entity. We're not talking about owners here. We do not call the ownership owners. They are members of an LLC. Everyone who has a stake in it becomes listed as a member. When the paperwork is done for an LLC, it lists the members of the LLC. I recently had the opportunity to help someone set one of these up. I've had and fielded calls just in the last week for some folks who were looking to try to set this up who had one in a different state, and they came down here and wanted to know the differences. And well, Florida's LLCs are renowned for what they do. So I told them, I said, look into it and give them where to go. You can find information about it, how to set it up in sunbiz.org. Sunbiz.org is your best friend if you're a small business owner. to help you get through everything that you need to do, from filing taxes to doing everything else. It does help. But for an LLC, it is a non-corporate business, so it's not a corporation. It is a company. It's a limited liability company, not corporation. The members of it maintain liability protection from what goes on within the company. It gives them a limited amount of protection as long as what they're doing is separate from what is going on with um, the company itself. So as long as you can see a difference between Joe Jones and Joe Jones Haircut LLC, whatever, as long as you can see a difference between the two, it is that limited liability stays in place. It permits all the members to participate in the management of the business, which is definitely different than how corporations are set up. And one thing that's important is that the number of members can be one, or it can be, up to whatever the statutory maximum may be in some areas. All right. So I know not everybody is Florida based, and so I want to make sure that you do understand that it's going to be a little different depending on the state you're in. The formation of it has to do with complying with the state's regulations, whatever they may be, whatever state that you're set up in. Those have to be complied with. And that in the state of Florida on sunbiz.org takes you to all that information. Once you're ready to set up your LLC, it gives you a whole laundry list of items to read through, to check, to see what each person that's going to be listed, what their role is, how important they are, the statutory type officers that you need for it, so that you have all the information you need there. LLCs do give that ability to set up the business for a relatively low price. The person, the LLC I helped set up a while back now, I guess it was probably a month ago or so. I want to say out the door, out of pocket, they spent getting copies of their LLC organizational papers sent from the state once they were approved. I want to say they were under $200 getting it set up. That's not including, of course, a fictitious name, but it is not a high amount that you're paying to set it up if you consider the amount of protection you get with the LLC setup. You have to file through the state. There will be filings that you have to do for an LLC in the state of Florida. You have to do an annual report. It is based on a year basis from when you set up. So you get a little bit of time if you set up at the end of the year. There are certain parameters that it gives you, and it gives you options of when you want to show the LLC as beginning, as opposed to when you file the paperwork. That does have to do with your taxing and how you're taxed for it. You do need a name for your LLC. That would be, you'll have the words limited liability company or LLC somewhere in the name. For most banks, if you want to set up one of these, you'll need to have a fictitious name filed anyway. It can't be going into your bank account. It's how they keep their business accounts separate. The contribution of a member can be in cash, property, services, promissory note of some sort, or other obligation to contribute cash, property, or perform services to the LLC. It's similar to in a corporation how someone can receive stock by either a cash purchase, the transition that's done through property or services, those type of things. So it's you buy into the membership in the same way as you would ownership in a corporation. There should be an operating agreement It's a basic contract governing how the LLC is run, rights and duties of the various members. That'll be a part of it. If it is a foreign limited liability company, now foreign is when it's done by any state other than that which in which it is formed. For this sense, so foreign just means that you're operating an LLC in the state of Florida that you set up in state of Connecticut and wherever. So maybe that's what you're doing, and you're wanting to work within that. There are some regulations that you have to abide by, and considering the price, how low priced it is, how easy it is. Um, from the time we sat down to form that LLC to the time that we were through with everything online, getting everything paid, all of it, we were sitting here for maybe 30 minutes. And that was me explaining a lot of the steps along the way to the individuals I was working with. And so that it does not take a lot of time. It's not time consuming to set it up. It's not really and truly uh, asset consuming. It doesn't take a lot of cash. So sometimes it's just easier to set it up. That's Florida. I'm not sure what other states, but Florida, it is simpler to set it up than to go through the process of doing something else. You need to know the rights of the members. What are the members going to be allowed to do? What are their rights when it comes to financial interest, managerial interest? What are they allowed to do? What have you stated in the agreement that everyone's going to be able to do? If for some reason you needed to make a distribution out of it, in other words, you're paying the members, because that's the reason we get into a business to receive a paycheck. We won't just open it up and not ever get anything out of it. So for the most part, we're looking to get something. So when it comes to distribution, how are we going to handle distributions to the various members? That needs to be noted as you set up your LLC so that you can handle that. You can do that within your articles that you have that you set up with your LLC. You'll need to have some type of uh, contract that dictates everything that goes into it so that everyone is covered and where they need to be. Profit and loss sharing. LLC's operating agreement determines how the partners allocate the profits and losses. You want to make sure that you're listing that. These steps. Now, it seems sort of repetitive, but these steps are important for you to make sure that you're getting everything that you need. All the members are going to be taken care of, and there's not any issues later on. I always say if I'm talking to someone, helping them set one of these up or set up a business of any sort, if I'm consulting with someone to do that, or if I'm teaching it here in the class, one thing that I always try to get everyone to understand, and I think it is just paramount to understand that the more you can do up front, the more questions you can answer at the beginning, the less problems you could have later on. So if I can decide now how we're going to divvy up the profits, if I can decide now how we're going to handle losses, if I can decide now when we're going to do a distribution, if I can decide all these things and kind of have that set aside and we all agree on it, if we're all members of the same LLC, then questions later on can be handled, answered now, and we can concentrate on running the LLC, running the company, making sure that we have a company that gives us a profit, that we do have a reason to discuss profit sharing and how the profits go out. So it's important to kind of knock that stuff out up front as much as you can, so there's not any questions later on that you're having to scramble to answer, ending up in messy court cases, those type of things. The more you can do now, the less trouble you have later on. Distributions, the members share in distributions, cash and other assets provided by the operating agreement, that contract we talked about earlier. If a member would like to withdraw and demand payment of their interest. Upon giving notice, they can do so. They have to give a notice, let everyone know, hey, I'm leaving the LLC. I'm withdrawing my membership, and I would like to have, my interest in the membership paid out to me. Uh, Once again, this is one of those things that you can state in your operating agreement. This is how this will be handled. We require a 30-day notice. We require, you know, a good faith gesture of what you're going to do next, what's going to go. So many states now do not honor, do not compete DNC. So you may not have something along those lines, but it's good just to kind of have, some information about when someone is withdrawing as a member, why it may be. If it's personal reasons, they're personal reasons, but it's good to know that in stating at the beginning in your operating agreement what needs to be done, how that's handled, will be very important. The management, in the absence of some contrary agreement, each member has equal right in the management of the LLC, but it may be managed by one or more managers who may be members. In setting up a LLC, you have to have your registered agent, of course, like you would for any type of business entity, and that person doesn't necessarily have to be a member. Someone who's managing can be hired by the LLC to manage the business of the LLC and not necessarily be a member. They can just be an employee of it, the same as an employee of Walmart or Target or anywhere like that. They're an employee. They're not someone who necessarily has a stake in it, other than making sure they run the business in the way that it needs to be run, so they can continue to receive a paycheck and the business can continue to stay open. It is sometimes beneficial for an LLC to have managers who may not necessarily be members, but they can be members. There's nothing stating that a member can also be part of the day-to-day managing of the hands-on managing of the company itself. LLCs specify voting rights of members, contrary to any provision that could be set up in the operating agreement. Must keep basic organizational financial records, and each member has a right to inspect those, of course, with a given notice. In any situation where if it's a partnership, a limited partnership, a LLC, or later in corporations, when someone wants to inspect the books, they have to give a notice that they're looking to inspect those. So it's, once a notice is given, and it doesn't have to be a long notice, but should be stipulated. Once again, something that's stipulated in there. Derivative action. A member has a right to bring an action on behalf of an LLC to recover a judgment in its favor if the manager or members with authority to bring the action have refused to do so. A derivative suit. This is something that you see in these LLCs. You also see them later on when we talk about corporations. It is a way to sue on behalf of the company, the business entity, to sue on behalf of it if something needs to be done that has not been taken care of. It is a case where the person bringing the suit does not receive any damages. If damages are granted, they are granted to the company itself. So the LLC receives whatever damages are granted by the suit. They do not go necessarily right to the member. The member does reap the rewards later on if it leads to a profit and a better standing for the company. So it does reap rewards for them, but it's not the same as a tort case that you take into court to seek compensatory or punitive damages. This is on behalf of the LLC, and anything awarded goes to the LLC. Assignment of the interest, unless it's otherwise provided in the operating agreement. Notice that all these allude to unless with the operating agreement, unless there's something different in it. A member may assign financial interest, and assignee of the financial interest may acquire The other rights by being admitted as a member of the company, if all due remaining members consent, with operating agreement provides so. A manager managed LLC, the manager of the manager managed LLC, they will have the duty of care and loyalty. Usually, the members of a manager managed LLC have no duty to the LLC or its members by reason of being members. Once again, that MMLLC, members of those have the same duties of care and loyalty that managers have in member management has the same as in a manager managed LLC. Hey, I should have, done a lot of talking and warmed up before I got into this one for these. No member or manager of an LLC is obligated personally for any debt, obligation, or liability of the LLC solely by reason of being a member or acting as a manager of the LLC. That's that limited liability part of the equation there. It's designed to keep you from having to take on debt or anything to do with the LLC that could affect your personal finances. It is completely separate. As long as it is ran separate, it will allow that to happen. Now, anytime we think about a business entity, we have to take on the thought of this may end. Right? Not every business goes on forever. Not every business is Walmart. It's been around, for years and years and years. Or, not everything's going to be that way. Some businesses last 2 years, some companies last 5 years, some last 6 months. So we always have to think about what happens when we dissolve it, when we go through a dissolution. A dissolution, an LLC will automatically dissolve upon the expiration of the LLC's agreed duration or happening of any event specified in the articles. You can set up an LLC, and it works real well for businesses who set up LLCs. When a corporation sets up an LLC to run a part of the business, it works real great if they have those set with an expiration date. By written consent of all the members is another way it can do it, or it could be court ordered to dissolve, the same as any type of business entity could be done that way due to debts, debtors suing, and it being handled through the courts in that way. Disassociation means that a member has ceased to be associated with the company through voluntary withdrawal, death, incompetence, expulsion, bankruptcy. When we go through a dissolution, we go through what is called a winding up period. That's the completing of any unfinished business, collecting debts, distributing any assets to creditors, and members also. It's also called liquidation. This is when you take everything that can be made liquid, you make it liquid, and you begin to pay off everyone who needs to be paid off. You're always going to pay your debts first before you pay your members. It is just the law of the land in good business practice that you pay off your creditors before you pay your members, and employees will get paid before the members also if you have employees that work. At a winding up, at a dissolution, and you're in the winding up period, employees who have remained on the payroll to this point, they're treated the same as creditors. They get paid before anybody below that creditor level gets paid. And so it's important to keep that in mind. The actual authority of a member or manager to act for the LLC terminates, except so far as may be appropriate to wind up any of the business. Parent authority continues unless notice of the dissolution is given to a third party. In other words, if someone is recognized as being able to speak on behalf of the LLC, they're considered an agent for the LLC. Until written notice is given to anyone they were a representative in front of, they will still consider that power in their hands until such a time as they're notified that we no longer have that, or this member no longer has that power to do that. How the assets are distributed. Now, this is where I want you to creditors, including members and managers who are creditors, except with respect to liabilities or distributions. To members and former members for any liabilities that they may have toward the company, and that's simply if they gave loans to the company, anything they've done, that needs to be paid to them, that will be what goes to them. Returns for contributions, unless it is otherwise agreed upon. Once again, that's something that you can set up at the very beginning, how that's going to be handled. To members for their LLC interest in the proportions in which members share in the distributions, unless otherwise agreed. If you merge the combination of assets of two or more business entities into one of the entities. In the effect of doing this, the surviving entity receives title to all of the assets of the merged entities and assumes all their liabilities. The merged entities cease to exist. You'd have a new one, and those that were merged cease to exist. Mergers work the same way across the board. How they're approved changes, but they work pretty much the same way across the board. Real quick, we're going to look at a limited liability partnership. This chapter starts with a limited partnership. Let's look at the LLP. It's a general partnership that, by making a statutory required filing, limits the liability of its partners for some or all of the partnership's obligations. It's a real simple way of saying that you take a partnership, apply the LLC principles to it, and you get what is called a limited liability partnership. A lot of your professional partnerships, with doctors, lawyers, whatever it may be, a lot of them set up under an LLP, so that they can, run pretty much the same way. Most states require only a majority of the partners to authorize registration as an LLP. The name of the LLP must include those words or the initials LLP. Yeah, the rest of that is not too big or broad there. All right, so that is chapter 32. Chapter 33, I'm going to task you with reading. It is how you form and the powers during formation of a corporation. Next week, we will do a video on, I believe it is 34 and 35. Need to look back at it and see for sure, but it'd be 34 and 35. So you'll have that one for the coming week. This one is coming out on Wednesday this week, so it gives you a few days to view it. They serve a couple of purposes. You can always go back and take notes for them when you're getting ready for the finals or midterms. They also just give you some reference if there's something you don't understand. And you've watched this, maybe you remember back, hey, Professor Thornton said, this or that, and that helps too. So if you have any questions, anything that you need to clear up about these chapters, or any of the stuff we're studying, anything to do with any of the assignments, please reach out to me. That's what I'm here for, not just to be a face on a screen, but also help you through if you have issues with assignments or anything else going on with the course. All right, so until next time, once again, if you have any questions, reach out to me. But until then, stay safe and study hard.